There were two important filings today, one in Washington, D.C., one in Florida, dealing with the federal charges against President Trump. And I want to focus right now on the so-called January 6th case, which has nothing to do with insurrection or sedition. It's just a pathetic case. And who better to have on the program to talk about it than Will Scharf? He's the candidate for Missouri Attorney General. I've endorsed him. And it's votescharf.com, votes SCHARF.com. Will, welcome back to the program. You wrote some very important, I think, legal analysis, related to the Trump lawyers' filings in Washington, D.C. Do you want to explain those, please?
Sure. And first of all, Mark, it's always great to join you. Appreciate you having me on. As you said, today in Washington, D.C., in federal court there, President Trump, his lawyers filed a pleading that could result in the dismissal of the entire case against him. I think it should result in the dismissal of the entire case against him. What his lawyers are arguing is that presidential immunity poses an absolute bar to prosecution here, that because these are acts that were taken while President Trump was in office that fall within the technical legal term as the outer perimeter of his presidential responsibilities, that he cannot be prosecuted for them unless he is first both impeached and convicted by the U.S. House of Representatives and the Senate, which he, of course, was not, in fact, convicted. So it's a really important filing. It's one that I expect will end up in front of the United States Supreme Court, I think potentially pretty soon. But it's an important day. It's a day that could result in that entire prosecution being thrown out.
All right, let me ask you a few questions. Number one, the judge is Tanya Chutkan, who should have recused herself. Overwhelming case that she's not of the judicial temperament to handle this particular case. So she'll be making the original ruling on this filing, will she not?
That's correct. And, you know, the Trump's lawyers have already made the argument for recusal that she's not been, let's say, favorably disposed towards. But significantly, immunity motions like this are typically immediately appealable. So the normal process for a case like this would be for this motion to be taken. She issues her ruling on it. And if she were to rule against it, I think there would be grounds for an immediate appeal, an interlocutory appeal, as it's called, up to the D.C. Circuit, where there are some good judges. And I think it would be, if not favorably received, certainly carefully looked at.
Now, if she, for the public out here, so if she rules, no, I'm not buying that, can she go ahead with the trial before the appeal is filed and heard?
I think President Trump's lawyers would have a very strong ground to request a stay pending final resolution of the issue on immunity. That's how this would work in the case of a claim of judicial immunity or legislative immunity. We're in somewhat untested grounds, of course, because no president before in American history has been criminally indicted for acts in office the way that President Trump has been indicted. But I think his legal team would have a very strong argument for a stay of all proceedings pending final resolution, even if that goes all the way up to the Supreme Court, of these presidential immunity issues.
Because if it isn't stayed, then what happens, of course, is this trial judge basically makes the ultimate decision. I don't mean of guilt and innocence and jail time. I mean the ultimate decision, because you're going to go through a full-fledged trial on a matter where you're challenging whether you should go through a full-fledged trial, correct?
That's right, and that's why it's so important that this particular motion has been brought when it's been brought. We're dealing with issues of immunity. Typically, the courts look at immunity claims and they try to decide that long before you get to trial, long before even trial preparation starts. That's the whole point of being immune from prosecution in cases like this. So even if things don't go well in front of the D.C. district, I'm hopeful. I know a lot of people who are watching this case closely are hopeful that the D.C. Circuit and potentially the Supreme Court, if it gets there, would issue a stay, would be willing to hold this case over until they at least deal with these crucial legal issues.
And speaking of the substance of this, we talk about immunity and the outer limits of immunity. The purpose of this immunity and the outer limits of immunity, is so that a president cannot be held criminally liable and then after he leaves office look over his shoulder about decisions he made as president of the United States, or any prosecutor, any federal prosecutor, would view an attack on a president making decisions as president as fair game, correct?
That's exactly right. So in Nixon v. Fitzgerald, which was a case from, I believe, 1982, the court held decisively that a president could not be held civilly liable for official acts that he made while he was in office, that presidential immunity essentially prohibited anybody from filing lawsuits for damages against a former president for acts that fell within even the outer limits of his presidential responsibilities. Now, again, no president has been criminally prosecuted for acts in office in American history before, so we're in untested legal territory. But I believe, and the filing that President Trump's lawyers put in front of the court today, I think makes a very good argument that the same rationale should apply here in criminal cases, that presidents shouldn't be looking over their shoulders potentially years after they leave office about whether their official act could result in criminal liability down the road.
Let's go to Florida. They filed there and they said, wait, we can't do this trial date. They haven't given us half the classified information they have. They haven't built or presented a skiff with us that we can use that's convenient for us to use, and a number of other things that the government's playing loose and fast with to make it extremely difficult to even prepare for trial. What do you think of that argument?
You know, Mark, I'm a former federal prosecutor. I did violent crime work in the Eastern District of Missouri in St. Louis, where we have a lot of violent crime. I mean, I've seen pretty open and shut carjacking and bank robbery cases drag on for years. The idea that this case, with already millions of pages of discovery, terabytes and terabytes of video data and other data, including classified information and other sensitive information, the idea that this trial was ever going to be ready for presentation to a jury on the timeline initially set, to me, that was always farcical. What President Trump's motion today lays out, I think, in great detail, is that DOJ has not turned over all the evidence they would need to present a fair defense for President Trump. Until they do, the case is obviously not ripe for trial. But even if everything had been turned over, the sheer volume of evidence involved in this case requires a much more deliberative process and a later trial date. I think they've asked for a trial date in late November 2024. I think that's eminently reasonable. I think even if they'd asked for much more time than that, it would be eminently reasonable. And fortunately, there you're in front of Judge Eileen Cannon, who's been a straight shooter so far. The liberal media says she's, some far-right conservative. She's not. She's just a fair, even-minded judge. And I think that I don't want to make predictions, but I think that motion is well taken, and I think they have a strong argument for delaying that trial until at least November of 2024, as they've requested.
And what about in Georgia? Former Attorney General Meese filed his own affidavit on behalf of one of the defendants, Joe Clark, the former Department of Justice official, who gave advice as a Department of Justice official regarding the Georgia election, and gave advice to the President of the United States, among others. And Attorney General Meese, like others, but he's got some heft. He says, this isn't a county or state case. A county or state can seize jurisdiction over federal officials who are making decisions as federal officials that affect a federal election. And so this matter must be presented in federal court. What do you think of that argument?
Well, first of all, I think the presidential immunity argument made in D.C., in federal court in D.C. today, equally applies to the Georgia case against President Trump. That if these were acts taken within the outer perimeter of the president's responsibilities as president, he should, in my view, be absolutely immune from prosecution. Notably, though, we're talking about a state versus federal issue here. We're talking about core principles of separation of powers of our constitutional system. I think the argument made in D.C. applies even more so to the Georgia prosecution against President Trump and the others he's been indicted with there. I expect that President Trump's lawyers will be making similar arguments in Georgia. But at the very least, we are talking about core federalism issues here, core constitutional issues. And I think that needs to underlie really all public conversation in these cases. Do we want any DA in the country to be able to insert themselves into national political processes in this way? Do we want, let's say in the case of Joe Biden, do we want him making presidential decisions thinking that, let's say a rural DA in Missouri could prosecute him after the fact for those decisions if we think he got it wrong?
We're here with Will Scharf. He's a good man, really superb lawyer, would be a great attorney general for the Show Me State, Missouri. And by the way, when I go to Missouri, don't show me anything if you get my drift. Anyway, it is the running for attorney general of Missouri. And you can go to votescharf.com, vote SCHARF.com. It beats the nutmeg state, which is Connecticut. Like, what do you mean the nutmeg state? Every state has sort of a weird, motto. Anyway, Will Scharf, I want to get a little bit into the general picture here, what's going on in New York with this civil case. It's my understanding you actually have a fraud statute in New York where you don't have to actually defraud anybody or actually commit an act of fraud. That is, no damage, no victims, no complainants. And somebody can go through your real estate portfolio and say, no, that should have been assessed this, that should have been assessed that. And we're even talking about matters that are long gone, where the loans have been made, they've been paid off, everybody's happy, it's done. The only reason you would pursue a case like that is to try and steal the property, the business from the Trumps, to eliminate the inheritance to the kids, and maybe even to bankrupt Trump. Isn't that true?
Yeah, I think you're touching on the most important issue in that case, Mark, which is that after 4 years of investigation, after 4 years of Tish James, the Attorney General in New York, and her team raking President Trump and raking the Trump organization over the coals, they have yet to identify a single person who was harmed, a single person who says, I made a loan to Trump and I regret that. I made a loan to Trump and I lost money on that. There is no victim here. So what they're really doing is, in this sort of weird academic way, bringing a claim over valuations that are years old, that are susceptible to any number of different interpretations. And as a result of their interpretation of what President Trump's assets should have been valued at years ago, we're talking a decade ago, because of their assumptions about what these assets were worth, they're trying to shut President Trump down. They're trying to shut down his businesses. And they're even denying him the right to a jury trial, which is core to American principles, the way the American legal system is supposed to work. It's a crazy case. Tish James came into office. She ran on the platform that she was going to get Trump, and that's what she's been pursuing every day for 4 years. But I think it's just so important to note that there is no victim here. There is no identified victim. And in light of that, it's just tough to see the rationale other than politics for pursuing this case this aggressively and pursuing this case in the way that they've pursued it.
I wonder if there's a constitutional issue here, because you're going to hold somebody liable. You're going to set up a kind of management of his assets, and under the law, as I understand it, the Attorney General herself would control the assets. You're going to prevent them from doing any business in New York State. You're going to pull all their certificates, prevent them from getting licenses, and then you're going to fine them $250 million. It seems to me that to be able to use a statute like this, which, by the way, is my understanding is it's almost never used, that there's got to be some constitutional defense, no?
Sure. So, Mark, as you know, I mean, you're a more experienced lawyer than I am. There are two basic kinds of claims in American courts: legal claims, which are claims for damages, and then equitable claims, which seek relief from courts. That would be injunctions, things that aren't sort of damages related, but you're requesting the court to intervene in a particular situation in a particular way. Now, legal claims, if they had brought a claim for damages against President Trump for $250 million, that would be subject, in most cases, to a right to a jury trial. Tish James and her team have claimed from the start that what they're actually seeking is equitable relief only, that they're seeking disgorgement of unjust profits or money that President Trump shouldn't have had. And that's how they've made this claim not susceptible to claims for a jury trial. And that's why they're arguing essentially that this judge, Engoron, has sort of absolute control over the case. But I believe, and a lot of other legal commentators believe, that what they're actually doing is disguising legal claims as equitable claims in order to prevent this from appearing even in front of a New York jury, that's how weak they believe their case is against President Trump, that they're not even willing to let it go in front of what you would think would be a pretty hostile jury in New York in terms of for President Trump. But this is a very, very strange case. Its proceedings have obviously been very, very strange so far. The appellate division of the New York courts has already smacked down this trial judge at least once as this case has progressed. And I expect that there are going to be numerous grounds for appeal of every decision along the way as we go forward.
And for most of these cases, unfortunately, you have to wait for an appeal or force an interlocutory appeal. And so they try and get their, their scarlet letter carved into his forehead. So on the way to appeal, people could say, oh, there, he's a fraudster on properties. Oh, there, he's a convicted felon on January 6th. Oh, there, look at that. He violated the Espionage Act. Isn't that the game that's going on here?
You know, Mark, President Trump has said consistently that all of these legal proceedings against him are really about election interference. That what the D.C. prosecution, the Florida prosecution, the state prosecutions in New York and Georgia, and now this Tish James civil action against him, what this is really all about is an effort to prevent him from running for president because they're just so terrified of him taking office again. And I think there's a lot of truth to that. I think there's a lot of evidence that supports that theory of the case, that there is no reason for these cases to be brought on the timeline that they've been brought on and in the way that they've been brought unless there's a bigger picture. And I believe that bigger picture is election interference, is making sure that President Trump's efforts to take back the White House are handicapped by his having to, as we've seen in the last couple of days, just sit in court defending himself against, in some cases, outrageous allegations.
And, everyone sees it. Everyone knows it. And yet it's celebrated by the media. It's celebrated by the Democrat Party. It's obviously being executed by Democrat district attorneys, and it's being executed by a Democrat-appointed phony special counsel. So this is really a cabal, and this is taking place. It is election interference like we've never seen in American history. We don't even have any criminal trials yet. We don't have any convictions yet. That's where they're headed. And we have judges who are, let me put it to you this way. I think the judiciary is destroying its own reputation with these cases, don't you?
Yeah, Mark, I read your most recent book. It's outstanding. All your listeners should buy it if they haven't already. You know better than anybody that all the left believes in is advancing more leftism. They don't believe in the Constitution. They don't believe in core American principles. Their end goal is just advancing more leftism. And they're willing to run roughshod over people's rights, whether it's you and me or, common man in the street, or whether it's President Trump. They're willing to run roughshod over people's rights. They're willing to run roughshod over the Constitution, over the separation of powers. They just don't care. They just want to make sure, that nobody can get in the way of advancing more leftism, which is their ultimate goal. And that's what's so dangerous about modern leftism.
The people of Missouri have a wonderful opportunity to elect you as Attorney General. I know there's an incumbent Attorney General. He gets a lot of publicity and so forth. But you are really a standout candidate, and you'd be a standout lawyer, and you'd be a standout Attorney General. And folks, if you want to help him, if you're in Missouri or not, and Mr. Producer, let's put this on our sites, please. It's votescharf.com. Vote SCHARF.com. You can hear how intelligent he is, what a great lawyer he is, how he breaks things down in plain English simply so everybody can understand. And I just wish you all the best, Will. You take care of yourself.
I appreciate it, Mark. Thanks so much for having me on, and thanks for everything that you do. Just telling truth to the people of America and fighting back against the mainstream narratives that are ultimately going to get us all killed. So thank you.
Yeah, amen. God bless you, brother. Take care of yourself. That's a really good guy, really good candidate.